Welcome back. Let's talk about the billionaires' legal loophole, why their money survives lawsuits and yours doesn't yet. Let's say you lose a lawsuit and the judge says pay $8 million, but you prepared properly. Your bank account, it's empty. Your property's mortgaged to the hilt. Your company, technically worth zero on paper. And here's the kicker, you're still rich. How? Because you use the billionaire's legal loophole, a loophole that's 100% legal, time-tested, and lawsuit-proof. If you set it up before the storm hits. And today I'm going to show you exactly how it works and why most lawyers won't even mention it. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been helping high net worth individuals protect their assets from lawsuits for the last 34 years, and I've set up more Cook Islands trusts than any firm in the world. And if you want to keep your assets secure, no matter what legal chaos hits next, go ahead and click that subscribe button. We talk strategies here that most attorneys won't touch. Let's get into it. Let me tell you a story. A real estate investor, I'll call him Jake. He built a $12 million portfolio over 15 years. He was smart, insured, had LLCs for each property, even had an umbrella policy, and then one of his tenants slipped, fell, and cracked their spine. The lawsuit was for $14 million, and Jake called his lawyer confident everything was fine. The lawyer said, you did everything right except protect your equity. The insurance company denied the claim. The LLCs didn't shield him because the plaintiff's attorney pierced the veil, claiming Jake commingled funds and ran things like a sole proprietorship. Jake settled for $6.2 million and his retirement was gone. So let's clear this up. What you own in your name is vulnerable. What your US-based LLCs own, often just as vulnerable. What's not vulnerable? A Cook Islands trust, a Belize trust, paired with the right structure. And this is where most asset protection videos stop, but I want you to understand the actual engine that drives the machine. So let's break it down. Step one, the Cook Islands Trust. And this is an irrevocable trust established under Cook Islands law. It's outside of the reach of U.S. courts, and no U.S. judges have jurisdiction there. Step number two, the Cook Islands LLC. The trust owns 100% of a Cook Islands LLC, and you, yes, you, are the manager of that LLC as long as the skies are clear. And that means you control the investments, the bank account, the assets until a lawsuit strikes. Step number three is the trigger mechanism. If you're sued, we initiate a duress clause, you step back in, our licensed bonded trustee in the Cook Islands steps in to manage the trust. So here's what this means. A U.S. judge says, give me the money. Our Cook Islands trustee law firm says, we don't recognize U.S. court orders. So you've legally lost control, so you're not held in contempt of court. In other words, if you had the direct power to bring the money back on your own accord, the judge could use that power and force you to bring it back. Your money stays protected, and here's the beauty. If no lawsuit ever comes, you're in full control the entire time. Now here's a cliffhanger for you. How fast can this protection kick in? Okay, let's talk timing. In the U.S., if you transfer assets into a U.S.-based trust after getting sued, a judge can generally reverse it under fraudulent conveyance. Now, sounds criminal because of the fraud word, but it's by and large a civil issue. That's just a term. Now, in the Cook Islands, they have a 2-year statute of limitations on fraudulent transfers. But here's the key. The assets are protected immediately. There's only 2 years to be able to challenge it, but even if they do beat the clock, you're still protected. And once the 2 years passes, or even sooner, if the cause of action wasn't foreseeable, it becomes nearly impossible for a creditor to touch the assets. In fact, we've set up more of these, like I say, than anybody else. We've never had one of our Cook Islands trusts penetrated. So to compare that to the U.S., where some states allow creditors to reach into the trust for up to 10 years if you file bankruptcy. 10 years. The moral to the story, the clock starts when you set up the trust. And that's why the rich do this in advance. You don't buy a fire extinguisher after the fire starts. But is it legal? Here's a question I get all the time. Business guy, that sounds shady. Is it even legal? Yes, the Cook Islands Trust is legal. The LLC is legal. The Swiss bank account where the assets sit, legal. What's not legal is fraud, like hiding assets after a divorce is served or lying under oath. So we work only with people who want to protect, not evade. You're putting up a legal wall before anyone ever picks up a sledgehammer. And that's exactly why this structure has been tested in U.S. courts, including the famous FTC versus Affordable Media case known as the Anderson case. In fact, I spoke to the Andersons before they passed away. Despite the FTC trying everything in its power, the court couldn't force the assets back into the U.S. The trust held firm. Now here's when people start getting ideas. What can you legally protect using this strategy? The answer: cash and securities, crypto wallets, LLC interests, business revenue, a brokerage account, especially if the brokerage account is a foreign one in the right jurisdiction if you want asset protection, like Switzerland, for example. Bank accounts, foreign again for asset protection purposes because U.S. courts have jurisdiction over U.S. banks. Proceeds from mortgages on U.S. property. We'll come back to this in a little bit. Okay, next, what about real estate? Well, you can't easily transfer U.S. real estate to an offshore location, and doing it in an offshore trust doesn't help because U.S. courts still have jurisdiction over the U.S. real estate, even if it is in a foreign trust. That could also create tax and legal problems. But you can protect the equity. So how do you do that? Using a land trust here. So a land trust owns the property. In other words, the land trust holds the title. And then if it's a rental property, not your personal residence, we have an LLC as the beneficiary of that land trust. And then we file a secured mortgage against that property, initially payable to the offshore LLC. That mortgage is recorded in the public records to look like a lien from a hard money lender, but it's actually you via your trust. Now keep in mind, this is an equity line of credit mortgage, so there's no money changing hands at this point. But what if a judge says, that's a fake loan? Well, let's talk about how to make it bulletproof. Equity stripping is like turning your home into a fortress. So imagine your $2 million rental apartment. You don't want to lose it. It's not practical to physically move it offshore. So we record a mortgage on that property for $1.6 million, held initially by your Cook Islands LLC that's inside of your offshore trust. So now the equity's gone. The home's not worth suing for. A creditor wins a judgment. They see a big property with a big loan attached and they walk away. So here's how to make that mortgage bulletproof. The loan documents look like any standard hard money loan. Here's a promissory note. Here are the repayment terms. There's an interest rate, and if needed, we get a third-party lender to acquire the loan, buying the loan and putting the proceeds into your offshore trust, making the proceeds untouchable. So again, the cash proceeds from the equity strip are placed into your offshore trust. The result, even if a judge suspects something fishy, they can't readily unwind it because the documents are tight. The lien is real and your equity, long gone. Now here's something most people don't consider. Most lawsuits settle, but how they settle depends on how lawsuit proof you look on paper. Trial attorneys are predators. They want easy prey. If you show up in a court with no visible assets, leveraged properties, and offshore structures, they think twice. And if they realize they'll have to fly to the Cook Islands, hire expensive legal counsel, and get past one of the world's most protective trust laws, they almost always walk. They want fish in a barrel, not sharks in a tank. So the question is, will you wait until somebody sues you to build a fortress? Or will you start now while you still have control? If you're serious about protecting your wealth from lawsuits, feel free to head on over to assetprotectionplanners.com. You got a lot of free information there. You can learn more. We've been doing this for over 3 decades, and we know how to keep your assets off the radar and out of reach. And don't forget to subscribe, because the next video could be the one that saves you millions. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. So stay protected, stay prepared, and I'll see you in the next video.